I would Let's start then by introducing our dear Professor Ester Renedo, who is a coordinator in terms of criminology at the very fine university in the memory of Queen Isabel I, which is located in Burgos. And Professor Renedo has already been a very close collaborator within the ELPIS context and has contributed a very interesting video within the ELPIS Velo review dealing with the topic, which she's going to deepen also today in her fine lecture. So, with no further ado, dear ladies and gentlemen, I may introduce our dear Professor Renedo to you, and dear Esta, es un gran placer y honor. So, you have the floor.
Thank you so much, Dimitrios, and agradezco tus palabras en español. I'm going to start my lesson, and I'm going to do a PPT for all of you. And today, first of all, I think I would like to thank you, Professor Vasco Pereira da Silva, for including me in the LPIS program, and to you, Professor Dimitrios, for organizing this conference with the LPIS US Law Transatlantic Legal Lecturers. And it's a pleasure to be here with you all today, and I hope you find this class of great interest. So let us begin. First of all, I think that the new technologies are very important for all of us. And I think the use of artificial intelligence in the administration of justice applied to the environment is a new deal for all of us, and I'm going to explain it in my lesson. Wait a minute. For summary, for all of us, the application of artificial intelligence is one of the milestones of the 21st century. The aim is to speed up judicial process in order to facilitate decisions by legal professionals. The application of artificial intelligence in environmental process will achieve homogeneity in this process. Currently, there is no homogeneity in environmental law, thus creating a common environmental law for all states and subject to the principle of universality. This IE will allow these processes to be more transparent and easier to trace across the globe with the varieties of the different national legislations. First of all, we are going to talk about international criminal law cooperation. All of us know what this means, but international criminal law cooperation through this text, the use of artificial intelligence in the administration of justice applied to the environment will be discussed. For example, environmental law in Spain is given by principle of the social and economical policy. It's stated at the Article 45 in the Spanish Constitution. And at the end, I have to translate it because I know the article in Spanish, but at the end it said solidaridad colectiva, that in English is based on the indispensable collective solidarity. This sentence, these words, will be the key to how the different states will have to process when applying the regulation of the environmental law. Therefore, judicial cooperation in criminal matters is based on the principle of mutual recognition of judgments and judicial decisions, and include measures to harmonize the laws of the different state members at the European Union and its member states based on the provision of the Article 82 to 86 of the Treaty on the Functioning in the European Union, the Treatment of Lisbon. They have provided with a more solid basis to the development of the area of criminal justice, while the European Parliament has been given new competencies. The second part of this lesson is what or which is environmental criminal law. I think that the different kind of attacks against environment committed by different subjects, whether natural or legal person, can be found to be similar or with certain similarities to the structures of attacks against human rights. These attacks gave rise to the creation of the International Criminal Court, and this similarity is based in two arguments. On one hand, there is a growing awareness to the protection of the environment, that is a global tax, whose effective protection does not have to depend on the capacity of the state to implement these kinds of regulations that are truly protective of the environment and then punish its infringements. Just the sanctioning of human rights violations cannot depend on the will or efficiency of a country's judicial system. The most serious environmental violations are no longer a national matter, but a matter of global governance. And I think that it's clear similarity in these two cases, which is why it should be reasonable in the medium short-term international organization, the establishment of a supranational court to punish this crime and deal with environmental issues. I think that is very difficult, but if we think that, or if we know that the human rights are similar than environmental law, we have to create a supranational court. We have to create a common set of rules. We have to know about the application of collective responsibility. And we know that there is a contrast between criminal law and administrative law, because criminal law is private law and administrative law is public law, and they are different. If we know these 5 components, we could create, and we can create, this environmental criminal law for all the states members of the European Union, or for all the states in the world, because we have to create a supranational court. Okay, it's the same thing as the case of Rwanda or the case of Nuremberg. But what are the criminal definition of the hypothetical criminal environmental law? Because it's difficult. I think in this hypothetical international criminal law, we will be the criminal offenses. The hypothetical criminal offenses that we are going to develop will be based in 2 pillars. In one hand, we know the collective responsibility, and in the other, the structural similarities with crimes against human rights. In this case, the need to decouple international environmental crimes for administrative environmental law means that neither the EU directive of the protection of the environment in criminal matters, nor the Council of Europe Convention can serve as a model for future international criminal law. The fact that 2 most important examples of international convention in this area cannot serve as a starting point makes global harmonization of this area, because this is difficult. And the EU directive links all these offenses to the violation of an European environmental law. All sanctioning behavior must, in this sense, be unlawful. Is the I think it's a rude term, but I think that at the same that is appropriate for knowing this behavior. The same applies to for all the 5 types of behavior referred to the Council of Europe Convention. Only the first of this is disassociated from the infringement of any environmental regulation. If environmental criminal law were to rely exclusively on individual responsibility, as in the statute of the International Criminal Court, corporate actors would be responsible for the operational failure that lead to the environment damage, as for example in the Bhopal case. This case, it's acted on the 3rd of December in 1984, and the most appalling industrial disaster in history occurred because of non-existent safety measures at the Union Carbide chemical factory in Bhopal. It was in India. Almost 500,000 people were exposed to the horrible toxic methyl gas, and it was really insane. Some of the theories they have been coined in this field, such as perpetration by means through organized of power, the redefinition of co-perpetration or commission by omission are in principle or theoretically possible to apply to some cases of crime against environment committed by multinational companies. Although international environmental law has not developed to the degree similar to that human rights, and there are some basic consensus of which criminal law intervention can begin to be structures. And I think there are these 4 structures to create this. On one hand, environmental violations can be compared to first-generation human rights violations. Understanding environmental damage as a potential economic damage affecting to the exploitation of natural resources themselves, and then sanctioning the environmental macro damage and the reconduction of environmental violations to first-generation human rights violations. And the end, I think that the prosecution of transnational environmental crime of damage is okay to introduce in this kind of knowledge by linking human rights violation to environmental law, is the different crimes as torture, genocide, crimes against humanity. We can see that this comparison of linkage can be bring to an end to environmental sovereignty that is based on the ownership of natural resources. Thus, the proposal to link environmental damage to international criminal law constitutes one of the most studied and still experimental environmental crime. That's it, this crime, ecocide. This figure was formulated by the doctrine at the beginning of the 90s, considering the accusation of malicious environmental damage with the intention of wiping out an ethnic group, race, or an indigenous community. Ecocide, as an international crime, would above all constitute as a spearhead which would make it possible to claim this jurisdiction of the International Criminal Court for these matters, and also to propose a strategic reform to the court statute that would make it possible to overcome the Nuremberg barrier, contemplating situations that go beyond behaviors committed in the context of war or armed conflict. Ecocide, for example, a very good example was the case in Argentina with the Mapuches group ethnic group that they, in this case, the company Benetton, buy the different lands in Argentina, and it was this group, the Mapuches population, and they exterminate them because they have to pay to the lands, okay? And this is a very example case of ecocide. The next criminal type, it could be geocide, but sorry, about the ecocide, because I think the idea is it's already present in the article 8.2, and it said it's a war, it's a crime to launch an attack intentionally with knowledge, and this will cause widespread long-term and severe damage to the natural environment, which is clearly excessive in relation to the military advantage sought. Despite the fact it's already regulated and can only be implemented and extended, it has major shortcomings for the current situation, as can be seen, for example, in the resolution of the International Criminal Tribunal for Rwanda. Despite the environmental damage resolution for that conflict, the environment is not mentioned once. In fact, if we analyze its resolution in the International Criminal Tribunal for Rwanda, in order to keep it in line with the Article 8.2, only obligates states to take into account to the protection of the environment, assessing whether the damage is proportionate and necessary for the achievement of militarily legitimate objectives. For this reason, the creation of the environmental law is intended to include it among human rights. Its core will be the transboundary damage and the traffic of natural goods, as traffic to protect species, traffic to dangerous substances, or traffic of waste. The different criminal types that I choose, the next will be geocide. It will be included widespread as long-lasting damage to the environment, done willfully or negligently, carried or without any economical or social justification, and which by its magnitude has an international dimension. The other, it could be patrimonicide. It will refer in addition to other candidates to plunderers of natural resources as a consequence of act of abuse of power, whether by country leaders or by multinational companies. This case, for example, we could see in the Amazonas. The other illicit is traffic offenses related to the environment. This will concern waste, protected species, and hazardous substance. And the last is serious transboundary environmental crime. It will cover case where damage to the environmental seriously affect either through injury or a specific danger the health of life of Nuremberg of people in another country. For example, the case of Chernobyl that affected Belarus, Russia, and Ukraine. I think these examples or this incipient harmonized environmental criminal law are, for example, the International Convention for the Prevention of Pollution from Ships, the MARPOL, whose function is to prohibit pollution discharges for large oil tankers, with the factor requires that their infringements be criminally punished by the signatory states. Similarity through custom offenses, smuggling, or environmental crimes, member states often already provide extensive protection for protected species in compliance with the Washington Convention or international trade in endangered species or with fauna and flora. The same applies to traffic in waste, the Convention of Permanent Organic Pollution and Article 4.3 on the Basel Convention. on the control of transboundary movements of hazardous waste and their disposals, oblige signatory states to consider illegal transboundary traffic in hazardous waste as a criminal offenses. In this specific field or international criminal law, the most important project is the draft code of crimes against the peace and security of mankind, the purpose of which was to extend the crimes under international law beyond this provide for the Nuremberg Charter, Article 76 of the draft code contains an offense called international and serious damage to the environment, which punishes whoever internationally causes of the causing of serious, lasting and widespread damage to the environment. And the brief of these various proposals for this environmental crime have shown that there is these 5 different approaches to criminalize these offenses. If we homogenize this criminal law in these 5 different approaches, we can create a common environmental law and we can protect the environment. But in this new part that I have to introduce to this lesson, I'm going to talk about the application of the artificial intelligence in the international criminal proceeding, and I think this part is the most interesting of the lesson, and we have to start it with this. The implementation of artificial intelligence. First of all, we know that the paradigm shift in criminal proceeding is completely linked to the implementation of the artificial intelligence. The change that they have taken place with the arrival to the society 4.0 and the so-called the fourth industrial revolution, together with globalization, have had a significant impact on crime, and in particular on the way crime is committed. This revolution, fourth revolution, have encouraged the environment to consider the environment as a third generation right, and the aim of the previous section is for environmental law to be considered as a human right. If we add globalization and the internet to all this, we can see how both effects have had very significant consequences in terms of criminality, and above all in the way crime is committed and the place where it's committed, since the same crime can use damage in a number of countries. With the creation of an international environmental law that will have competencies in both sanctioning and criminal matters, the necessary actions will be created for the prosecution of these new forms and crime and their challenges and transformations, which include from the use of new technological mechanisms and for the identification, prosecution of this type of crime to the massive processing of information by intelligent systems. This new technological environment highlights the importance of data information, its use and its traffic through new online platforms, from the electronic transmission of requests from international legal cooperation between central authorities, will make it possible to manage digitality since requests for international legal cooperation in a secure communication environment between central authorities. All of this undoubtedly calls for in-depth study of the changes that they are taking place and will surely continue to take place in this area of criminal procedure laws. We must understand the network as a multifaceted and multi-offensive channel from which different individual and collective legal assets can be attacked at the same time, causing damage in different parts of the world at the same time. Thus, the phenomenon of the online crime has a transnational character. In addition, new concepts such as deep web or dark web terms that are often confused have been added recently. It's common in the daily judicial practice. The many proceedings end up being achieved due to this issue. There are international obstacles to the transfer of electronic data, which means that when we challenge evidence of this nature, and we ask a foreign server for the complete and authenticate information, the response never arrives or is negative as is located in a jurisdiction other than Spain, for example. There is no specific bilateral agreement on the transfer of electronic evidence for one country to another. Certainly, if we turn to the for example, if we use the Spanish example, Ley Orgánica del Poder Judicial, the judicial power, we will be talking about the preferential application of the territoriality criterion to assign jurisdiction to Spain and competence to the criminal courts. For example, in Spain, the Spanish civil court shall hear claims arising in Spanish territory in accordance with the provision of international treaties and different conventions to which Spain is party, the rules of the European Union and the Spanish law. But we are actually faces a first crossroad, and these unlawful acts have a clear projection of extraterritoriality. Given the principle of territoriality is understood to be linked to the place where the crime is committed. Cybercrimes can also be understood to have been committed in another jurisdiction in application to the theory of their results. In other words, even if the attacks in Spain, the criminal results can occur in several countries at the same time. This in turn generates problems of jurisdiction and the need for new procedural instruments for international cooperation in the investigation, prosecution, and trial states, since many countries have options to initiate actions at the same time in order to elucidate the acts that they are committed. In this sense, Spain could have jurisdiction if the perpetrators commits crimes from Spanish territory through the use of the network as a vehicle for committing crimes. This will save time in duplicative investigations and avoid duplicative investigation that would determine the common cooperation principle than of non bis in idem, while saving procedural costs for different countries and preventing these legislative distortions from being exploited by criminals to commit cybercrimes in area of apparent impunity. I have to retrocede to the other PPT because in this explication I explain, for example, these 5 criminal types One group is the place of your commission, ecocide, geocide, and patrimonies, and in the other part, principle of universal justice, it recognizes illicit traffic crimes related to the environment and serious transboundary environmental crimes. But we have to explain how to artificial intelligence will play a role in this process. The application of artificial intelligence of the administration of justice is one of the milestones of the 21st century. The aim of this application is to speed up judicial process in order to facilitate decisions for legal professionals such as judges and prosecutors. However, the application of artificial intelligence to the administration of justice is conditioned by the following problem. Can we let an algorithm decide on the meaning of a decision? The problem deriving for the application of these technologies to judicial decisions is linked to the functioning of black box systems, okay? But first of all, I think that the implementation of artificial intelligence in deep learning is very difficult. The problem arising for the application of these technologies to judicial decision is linked to the functioning of black box system. I'm going to explain it. Before defining the deep learning, we must to place it within machine learning, a type of artificial intelligence that consists of training the machine with the aim of recognizing patterns. And in depth learning, as a subset of machine learning, the algorithm is able to reason and draw its own conclusion with machine learning. And we are going to explain this kind of terms because they are a little bit difficult. What is artificial intelligence? We have to imagine artificial intelligence as a big circle, okay, the big green circle. Inside there is the machine learning, and inside the machine learning there is the deep learning. And I'm going to explain this term. These different terms are artificial intelligence in the context of computer science is the set of system of combination of algorithms purpose is to create machines that mimic human intelligence to perform tasks and can improve according to the information they collect. The machine learning, the second circle. The first of them will be supervised machine learning, which is machine learning an expert or a small group of experts supervise the development of the learning process of the algorithm, improving the increase of its learning curve. On the other hand, unsupervised machine learning is a type or machine learning algorithm that make its own inference from the databases, which can lead to errors to the creation of undetermined rules in the algorithm programming process. And at the end, the little circle, the deep learning, or the black box. In deep learning, as a subset of machine learning, the algorithm is able to reason and draw its own conclusion. With machine learning, its applications to the real world will increasingly tangible. The main problem with this variant is that it throws up a decision without us knowing the process that has led to it. That is, we don't know the logic of the argumentation. Now that we know and we have cleared this kind of concept about the artificial intelligence, we know that the problem deriving for the application of these technologies to the judicial decision is linked to the functioning of black box system, this deep learning, the little circle, Before defining this term, we must place it within machine learning, a type of an artificial intelligence that consists of training the machine with the aim of recognize patterns based on the data and of the basis they making predictions. Machine learning can be also classified in these two parts that I have to that I explained before. The supervised machine learning, which is a machine learning an expert or a small group of experts supervise the development of the learning process of the algorithm, improving the increase of this learning curve. And on the other hand, there is the unsupervised machine learning, is a type or of automatic learning of the algorithm that make its own inference from the databases, which can lead to errors of the creation of undetermined rules in the algorithm programming process. And at the end, in the deep learning of a subset as a machine learning, the algorithm is able to reason and draw its own conclusions. The main problem with this variant is that it makes a decision without us, without knowing the process that lead to it. For example, we don't know the logic of the argumentation. This happens because the inputs, the databases that we introduce in the machine learning are the ones that design the algorithm by virtue of which decision the outputs is provided. However, we humans don't know what process has been followed, as we are only provided with the final resolution. And we have the solution. We are human. We have always the solution from all these kind of problems. An alternative to the implementation of this system is based in another variant of machine learning that we call decision trees. The decision trees this allows us to monitor the data entered in order to understand the logic of this operation and the reason for the decision. These decision trees, we have to imagine like a tree, because we have different parts, and this kind of different parts are giving to us a different kind of resolution. For this reason, decision trees will be a very flamboyant alternative for introducing artificial intelligence into the process within the administration of justice. Within these decision trees, we can find this kind of elements. The first element is name classification models. This consists of predicting the value of a variable by classifying the information according to another variables, type, group, membership, etc. The values they produce are predefined. For example, the results are defined in a set of possible values. The other decision is the regression models. The regression models, an attempt is made to predict the value of some variables as a function of other variables. Is the opposite as classification models that are independent for each other. The regression models are completely independent, but the classification models are predefined, and they are joined the different resolutions. In the regression models, an attempt is made to predict the value of some variables as a function of other variables that are independent for each other. The possible outcome is not part of predefined set, but can take any possible value. The decision tree is a structure that consists in several branches, nodes of different types. We have the classification models and the regression models, and then we have the other parts of the tree. The first one is internal, are internal nodes. Internal nodes represent each of the characteristics or properties to be considered in making a decision. The other part of the tree are branches. Branches represent the decision based on a certain condition. And at the end nodes that represent the outcome of the decision. Within the administration of justice, this type of technology is of interest for making minor decisions in order to reduce the workload of justice professionals and facilitate the document management. This application of artificial intelligence has already been seen in different administrations. For example, in Spain, we have two ministers that are started to apply this kind of activities. But we have to involve this process, because we have a lot of questions about the application of artificial intelligence, and we know the logic of the argument. This is because the inputs that design the algorithm, that I have to explain before, by virtue of with the decision is the output, because it is the way that the machine exposes the different decision. However, we human beings don't know how to process has been followed, and it's only provide us with the resolution. The other part, an alternative to implementation of this system is based on another variant of machine learning, is that we call the final decision trees. This allows us to keep track of the data entered in order to understand the logic of their operation and the reason for the decision. Within the administration of justice, this type of technology is of interest for many of these decisions, and the analysis that we are doing to address in the implement of the artificial intelligence system to determine the jurisdictional competence of a problem is very difficult to introduce to this kind of process if the expert, the judge, lawyers, etc., they don't know how to apply it. It's a very difficult technology, and we have to study before apply it. But in Spain, sorry, how these processes? Automatic decision making by artificial intelligence and the revolution it presents. As we know, the use of the computer is not new in the field of public services to the citizens. The use of computer technology for calculation and verification operation is frequent and common in the public sector, sufficient it to refer to the tax administration in its verification process, or to prevent irregular conduct. Can be read in the white paper of artificial intelligence. In the European Union, we have two books. The first was in 2018 and the second is in the 2020. And it defines artificial intelligence as a combination of technologies bringing together data. But we don't have any harmonization in the states member legislation, okay? And the benefits mentioned will arise from the use of in-service in public interest. In Spain, sorry, we have this picture in Spanish, but automatic decision in the application of the artificial intelligence and the revolution that it presents. We have two ministers in Spain. The first one, Ministerio de Hacienda, the taxes minister. We have to, this minister start to introduce this application. Has already been in the use of big data, in the use of drones, in the use of tax microanalyze. We already implement. The other minister in Spain that applies this artificial intelligence is MITECO, Ministerio de la Transición Ecológica y Medio Ambiente, in English, the Ministry of Environment, Ecological Transition and Demographic College, has also implemented the use of artificial intelligence for the pursuit of forest fires. They have to contract a multinational that it's called IBM, and the IBM company has initiated the application of artificial intelligence with a program that is called Beach Fire Detection program, which is able to calculate the probability of a fire occurring and its path. To detect illegal deforestation in the Amazonia, they have a program that is called a Rainforest Connection. The Rainforest Correction Program has also been launched in very concrete part of the Amazonia region, a program that recycles mobile phones to help to protect the rainforest from the illegal logging using this kind of artificial intelligence. This program has been successful in targeting the detection of sounds that may be dangerous to the environment in protected forest areas such as rainforest. These programs take advantages of the automation that artificial intelligence offers, and the economic impact it derived from it, especially when considering the wider ramification of change and the long-term consequences if illegal deforestation is not stopped. Things are moving fast, faster even than our capacity can understand. The truth is that the response of law, and more specifically in administrative law, to these changes is usually more slower. The public administration has largely lost the leadership that characteristic is until the last century, and today innovation without prejudice to relevant examples in the public field is led by the private world. All of us know this kind of material about the public administration, and the public administration. For example, if we read this picture, we know that the white paper in the European Union identified three sectors that will be affected by the artificial intelligence: the public sector, the private sector, and the cross-country research sector. As far as the public sector is concerned, it states that aims to promote the adoption by artificial intelligence by the public sector. But this kind of automated decisions making by the public administration and the revolution. As we know, the use of computers is not new in the field of public services to the citizens. Indeed, as can be read the white paper of artificial intelligence that I mentioned before, it is published by the European Commission in Brussels in the 2020. And it says that artificial intelligence is a combination of technologies bringing together data, algorithms, and computing power. It's okay, we know, but we can't apply it because we don't know enough about these new technologies. In this kind of technologies, I think from a point of view that this application to environmental criminal law is much easier than the application to administrative law. I think this probably the administrative law is public law and is I don't know exactly the word in English, but administrative law is shorter in time than private law because we have different public policies that introduce their public culture, for example, the different kind of ministers, and is difficult to apply it to the administrative process. From my point of view, when we finish the lesson, we can discuss about this point. In despite the administrative law in recent times, I think that it's difficult to find an area in which the impact of technological developments of a specific branch of the legal system and or not the institution responsible for the task linked to the legal discipline is not analyzed, but not only because what is currently the object of attention lacks a single academic of science location of study, is that not fit easily into any of the legal branches proper to the classic separation existing in our system. It's not public law, it's not private law, because this has notable implication for each and for everyone for them. It's good without saying for example, in Spain, if we have to apply artificial intelligence to the ordinary administrative process, for drawing general provision is currently undergoing a profound process of both formal and substantial transfer. Formal, because for some time now, there has been an extraordinarily legal substantial transformation for procedure, and this explains the legal provision of the principles of good regulation. The good regulation in the Spanish process, in the Spanish administrative process, is a regulation in the article 129 in according to the principles of necessity, effectiveness, proportionality, legality, certainty, transparency, and efficiency. And I think they are all the principles. But if we have to introduce artificial intelligence, we can improve this kind of process. Therefore, this work is based on an hypothesis for the future, because in Spain, technological innovation and digital transformation have barely begun to be introduced into the regulatory process. They are barely completed process in the legislation enforced, because the life cycle of the public law rule, and in particular the administrative law, is much shorter than of private law rule, which is intended to remain in the legal system and is not focused of criticisms about its lack of quality, the much reported crisis of the law. The specific object is the use of technological innovations by public authorities, and among them in particularly the undoubtedly most extraordinary technology generally called artificial intelligence. Answering the different kind of questions to the application of the artificial intelligence in the administrative law, the truth is that the response of law, and more specifically as far as I'm concerned, administrative law, to this change is usually much slower. The power administration has largely lost the leadership, and specifically artificial intelligence is transforming the paradigms that govern approach to many problems. Okay, and at the end of this lesson, I think that artificial law, the specific object of attention, is the use of technological innovation by the public authorities, and among them in particular, the most extraordinary this kind of technology. That is the branch of science closely linked to computing, which tries to imitate the human being, is in his thinking, in his reasoning. Therefore, it's likely that we are witnessing the birth of a new discipline, artificial law, in a substantive sense, as a set of principles and legal technical rules that order the situations and their relationship in which an artificial or inhuman object with physical and mental capacity concurs. Finally, artificial intelligence, that I think that this new area in law, artificial law, is not private law, is not public law, is not criminal law, is not administrative law. I think artificial law is a new specific object, a new subject, and it has to apply to all of the different law areas. I think artificial law is it could be applied in a future in administrative law, in criminal law, in civil law, in different areas of law, because we have to start to introduce this kind of technologies, and these technologies are involving the different kind of relationships between the machine and the humans. And that's all. I finished my presentation, and I hope that all of you like it. And if you had any questions, I'm going to answer you.
Well, thank you very much, dear Esther, for this very rich and very interesting lecture. A cordial thank you from our part. I would have a question, but I'd rather not be the first one to go. So, dear ladies and gentlemen, are there any questions from your side to our dear Professor Renedo? I mean, it's a golden opportunity to request the matters of artificial intelligence here, and because artificial intelligence is obviously all over the place and also torturing the lawmakers all over the world right now.
Sorry, Dimitrios, because
Yeah.
I don't hear you clearly.
You don't hear me?
No,
Maybe it is
I see you, but I can't hear you properly.
just a sec.
Sorry.
Is it better now?
Yes, now I hear you, but I don't see you.
Well,
It doesn't,
it's
it
not,
doesn't matter.
that's not a big loss. As long as you can hear me, it's fine.
No. I prefer to hear you and to see you at the same time, but it's okay. It doesn't matter. Sorry, could you repeat the question if you
Well, if
and
there are no
we could have a conversation about artificial intelligence between us or the different kind of participants
of
of the lesson.
Well, if there are no questions
There are no questions.
by our dear auditory here, I'd like to ask you, since your lecture was twofold, and you mentioned also matters of that was particularly interesting. Also, the thought and the proposal of further harmonization in terms of environmental criminal law in an international framework. I'd like to ask you, since the European Union has struggled to find compromises. Um, are you optimistic in terms of further harmonization at the level of the European Union, considering, for instance, that yeah, let's say the Green Deal has had some issues, you know what I mean? So and so, would you be optimistic in terms of the European Union for further harmonization of environmental law?
It's a very good question, because I don't know think so, because this week, on today's 23rd,
Hmm.
on Monday, as you know, Spain has the presidents of the Council of Europe, and they propose the this kind of harmonization of the environmental criminal law to the different to the all of the states member of the European Union. And the Spanish Minister of Justice, Pilar Job, said that it's unnecessary. No, it was unnecessary, and it's only I don't know, utopic, or I don't know exactly the words in Spanish, because I having to translate it in my mind, because in Spanish she said that que no era necesario, no era suficiente, it's enough, it's not necessary for the environment to harmonize this kind of process. And we have the Green Deal, we have the treatment of Paris, we have the economical, the program of a circular economical and sustainability. We have a lot of different kind of treatments, cards, books about the environment at the European Union. But Spain has the opportunity this week to change this kind of problems to the different member states of the European Union, and we didn't do nothing.
Eh, in any case, there are still some weeks left for the Spanish presidency, so don't worry.
Yes.
maybe maybe something else is gonna come around. So some other solutions and
I
insight.
know that about this part for the question of the environment, but for the question to the artificial intelligence, now I think that the European Parliament are writing the new reglement of artificial intelligence,
Yeah,
because we have the I don't know in English, the protección de datos,
the data protection
the
matter.
data protection. Thank you, Dimitrios. We have the reglement and the law of the data protection, but we don't know we don't have anything about artificial intelligence. And I think the next year we probably can show this reglement for the Parliament, European Parliament, but I don't know. I don't have a crystal ball to predict these activities, but I think it's necessary to introduce these new technologies. And for the environmental law, that is the subject or the area that I'm specialized, I think the European Union have to provide or have to improve a big effort to introduce this kind of things that I have to explain in this lesson, because environment is all for us. It's our habitat, and if we destroy it, we don't have nothing. This is my conclusion, Dimitrios.
No, no, that's perfectly true. And in terms of not ending in a too melancholy note,
Yes.
but you're perfectly right. That is exactly the issue. Dear ladies and gentlemen, are there any further questions to our dear Professor Renedo here? That seems not to be the case. Then, in any case, dear Esther, I'd like to thank you warmly for this, as I said, very rich lecture and very interesting one. It was a great honor and pleasure to have you here with us. And dear ladies and gentlemen, also a heartfelt thank you to all of you who were here in the auditory and followed this very interesting lecture. Also, a heartfelt thank you to our dear Andrea, who provides the virtual room for our lecture series. And dear Esther, please give my best also to Fermin Carrillo of your university,
Fermín
and
Carrillo,
Clara,
okay.
Clara Rojo also. Uh, my best wishes. So take good care of yourselves. Thank you very much, and see you all soon again. Thank you warmly.